Well, good afternoon, everyone, and welcome to the Canada-United States Law Institute Conference on an important legal issue facing Canada and the United States. And it has to do with a new law in Quebec that's come into force about preserving and protecting and advancing the French language. This is being put on by the Canada-United States Law Institute, which was started in 1976 as a conference and a partnership between the Faculty of Law of the University of Western Ontario and Case Western Reserve University. And since that time, this institute has been dedicated to examining legal and policy issues facing Canada and the United States. We've done this through our annual conferences, our experts meetings, and our publication, the Canada-United States Law Journal. So before I begin, I would like to just let everyone know that there will be an experts meeting in Washington, D.C. this coming November, in which we, along with the Wilson Center, will examine trade sanctions and how they are working in the U.S. and Canadian approach to them. Then we will have our annual conference on April 18th and 19th in Cleveland in 2024. And that conference will be dedicated to the interplay and the intersection of human rights and supply chains. Today we're here to talk, as I mentioned, about a new law in Quebec, which has come into force to protect and enforce the use of the French language. Moderating this panel is Kimberly Eberwein. Kimberly is a graduate in 1996 of Miami University. After that, she worked in the hospitality and advertising industry, and then she went to law school here at Case Western Reserve University, graduating in 2005. She spent several years with the law firm of Squires, Sanders and Dempsey, now Squires Patton Boggs, before taking a position at Procter & Gamble. She's going on 14 years at Procter & Gamble and now holds the esteemed position of General Counsel Canada for this global consumer goods giant, Procter & Gamble. This job of hers involves all kinds of issues and requires a lot of translating, not only language, but cultures. And by the way, she is the newest member of the executive committee of the Canada-United States Law Institute. So over to you, Kimberly.
Merci, bonjour et merci à tous d'avoir participé au webinaire aujourd'hui. Je suis honorée d'être ici avec ce merveilleux panel pour discuter du topic de la loi 87. Et maintenant en anglais, parce que c'est ma langue. Thank you so much. Welcome to everybody for joining the webinar today. I am terribly honored to be here today with this wonderful panel to talk about Bill 96, which is an act respecting French in Quebec that, as Stephen just mentioned, has taken effect and now is something that everybody will have the distinct pleasure of putting into effect in their businesses and in their home lives. I'm joined today by, as I mentioned, a fantastic team of lawyers, primarily headquartered in Montreal, but also in the United States. We have Christian Bolduc, who is from Smart and Bigger. We have Melissa Tehrani, who is from Gowlings, Corina Manol from Tories, and Susie Ruiz-Lichter, who is from my alma mater of Squire Patton Boggs. And today we're going to cover myriad topics. Many of us deal with one aspect of Bill 96 or the other, but as you will come to learn, Bill 96 and the Charter of the French language is a massive piece of legislation that touches many aspects of lives within Quebec. In particular, what we'll talk about today is the provisions relating to trademarks and signage, so on package and signs outside of a retail establishment. We're going to talk about how Bill 96 impacts contracts and engagements between businesses that are reaching into the province. We're also going to talk about the labor and employment provisions that anybody with employees sitting in Quebec will need to know and take on board as they continue to manage those individuals. And then we'll hear also about the consequences of not complying with Bill 96. And finally, we'll hear the US perspective, particularly with respect to the trademark provisions, which have quite a direct impact or could have a direct impact on marks holders who sit in the United States. And so, having said all of that, I am not the star of the show. We have so many other people here who are going to say many, many more interesting things than I will, and in much better French if they're called upon to do so. Hopefully you all can see my screen. I'm now going to hand it over to Christian Bolde from Smart and Bigger to give us an overview of the Charter of the French Language, just so that we're all grounded on the same foundational principles. Over to you, Christian.
Thank you, Kimberly. A pleasure to be here today. Merci beaucoup. What's Bill 96? Well, Bill 96 has to be placed in a context, and one of the good things about Bill 96 is that it's brought a lot of attention to the Charter of the French Language, a piece of legislation that has existed for almost 50 years in Quebec, and that protects the French language in all spheres of public life, such as going to court, going to school, the workplace, and also businesses. So it affects all those aspects of what we refer to as public life. Now, of course, where is that applicable in Canada? Well, it's applicable in Quebec. So that's this big red spot that you see on the screen, which I had an interesting argument with a friend of mine who's based in the US, was telling me that Texas is bigger than Quebec. Well, it is not. So Texas fits more than twice in this large province. So that's where the charter is applicable, whether you're based there or whether you do business there. And you'll hear more about that a little bit later. Now, Bill 96 changes the French charter. It changes also other statutes. So it was sanctioned last June. So in June of last year, there were many revisions to the actual French charter. A right of action under the charter, the Quebec Charter of Human Rights and Freedom, was also provided for, and you'll hear about that also later. The complaint process has been changed. The powers of the Office Québécois de la Langue Française, referred to as OQLF, a name that you're going to hear about a lot today, have been increased. The fines have been increased, and therefore, as you know, there's impact on education, commerce, the courts, businesses, and so on and so forth. So I will now turn it to Melissa, to you.
Thanks, Christian. So before we jump into Bill 96 and the forthcoming changes, we thought we'd start off with a quick level set of the current French language requirements. What Christian and I came to realize over the last little while is that there are still many companies operating in Quebec that may be unaware of Quebec's longstanding French language requirements, and that are under the impression that Bill 96 introduces entirely new translation requirements, which it certainly does, but it also significantly amends existing requirements. And it's those existing requirements that not everyone is necessarily up to speed on. So I thought we could begin with certain rules that are currently in force and that have been for quite some time. So the first is customer and client service. So the charter has for decades stated that consumers of goods and services have the right to be served and informed in French in the province. And while the general provisions of the charter could have been interpreted as applying to both the B2C and the B2B space, there may have been some uncertainty regarding whether this provision, which speaks to consumers, and so a natural person, also applied to merchants and other businesses. So to address this issue, Bill 96 now includes a mirror provision for businesses, which now explicitly provides that businesses that offer goods and services to a public other than consumers must also inform and serve said clients in French. And so whether you're a company that operates exclusively in the B2B space or that is in the B2C space, but also interacts with suppliers, vendors, or other businesses in Quebec, you'll want to ensure that you have systems and processes in place to support serving those clients in French. Product packaging and labeling. The new rules regarding product packaging and labeling are causing tremendous stress and anxiety for our clients, especially those in the CPG industry, which ranges from personal care products to automotive and tech. But before we dive into Bill 96, it's important to kind of touch on the current requirements. So the rule for product packaging and labeling is fairly simple. All copy on a product, on its container, on its wrapping, or documents supplied with the product must be in French. And this includes not just the outer packaging, so think of a box that a tube of toothpaste might be sold in, but also the inscriptions on the tube itself, as well as any directions for use or pamphlets, coupons, promotional copy that you may find within the outer packaging of a product. So it has to be in French. That copy may also be translated into another or into multiple languages, provided that no other language is given greater prominence. So in other words, the French copy must be afforded at least equal prominence in terms of font size, content, overall presentation. I will say that Bill 96 does amend Section 51 by adding the copy that you see there in red, which specifies that no translation may be available on more favorable terms. So although Bill 96 doesn't define what on terms that are at least as favorable constitute, I think we can reasonably, those can be reasonably be understood as meaning to require that the French version be no more difficult to access, for example. So a clear example of that would be if you had the directions for use in English on the actual product itself, but only offered a URL to the French translation. So in that case, the English copy would certainly be available on terms that are more favorable. It would be directly in the pack, whereas the French copy would be available online only. And so that would certainly be offside. Commercial publications. Catalogs, brochures, folders, commercial directories, order forms, any similar publications have to be in French. They can also be in French and in another or multiple languages, provided again that the French version is equally prominent. But since the charter was drafted back in the 70s and way before the internet became mainstream, prior to June 1 of last year, you would have been hard-pressed to find any mention of websites, social media, or digital advertising in the charter. And so Bill 96 filled that gap by adding the expression regardless of the medium used. And so now we're expressly requiring that any digital or online version of a catalog or brochure or similar publication has to be in French, which extends to commercial websites and social media accounts. And this is actually one of those rules that seems somewhat new to many businesses. And one question that I have been receiving quite often lately is, well, when does the requirement for me to translate my website come into force? And the answer is it's been in force for nearly 50 years, right? And so to be clear, the OQLF has always been of the view that websites and corporate social media accounts are subject to this Section 52. It's now just unequivocally the case in the legislation. And so in practice, you would want to ensure that if you have a French version of your website, that you essentially have a mirror version in English as well, if you wanted to have dual language. And the French version of that site would have to be identical to the version in any other language in terms of content, presentation, as well as functionality. So for instance, if the English version of your site offers a possibility to chat with a customer service agent, then you'll also want to ensure that that is offered on the French version as well. So next up is signage. So when we talk about signage, posters, and commercial advertising, we're not talking about any and all forms of commercial advertising. It's really much more tailored to point of sale signs, billboards, outdoor and storefront signage, office signage, product displays, just to name a few. And the rule for signage differs. So while it does have to be in French, signage may only be in another language as well if the French version is markedly predominant. And there's actually an entire regulation that sets out what that means, and it's quite aptly entitled the Regulation Defining the Scope of the Expression Markedly Predominant for the Purposes of the Charter. And overall, the French copy has to be given much greater visual impact. And the requirements differ depending on whether the English and French copy are on the same sign, on separate signs of the same size, on separate signs of different sizing, etc. And so if we take the case of a singular sign with English and French copy appearing on the same sign, in order for the French copy to be markedly predominant, the French font and the area allotted to the French copy would need to be twice the size of the English font and the area allotted to the English copy. Before I turn it back to Christian, I should mention that there are some exceptions to this rule, and there are circumstances where signage must be exclusively in French or where the equal prominence rule might also apply. But I'll now turn it back to Christian, who will speak to trademarks and the recognized trademark exceptions.
Thank you, Melissa. So I'll talk about the trademark exception in general, and then I'll focus a bit about on the changes brought upon Bill 96 as far as they impact this trademark exception when it comes to product markings and accompanying documentation. So that will be our focus over the next couple of slides. But first, we need to talk about what is the law today regarding the trademark exception, because the changes that will come into force that will affect the trademark exception will come into force in a little bit less than 2 years from now, on June 1st, 2025. So what is the trademark exception? So under the Charter of the French language, a recognized trademark does not need, that is in a language obviously other than French, doesn't need to be translated into French, so long as a French version of the trademark has not been previously registered in Canada. Now, we could debate about what's a French version. It's not defined in the statute in question, but I would say that it's probably fair to say that it's a French equivalent, a French version. I think in general probably refers to something that would fall into the category of a literal translation or something close to it. If it's completely different, but in French, would that be categorized as a French version? That's probably where we get into this gray area. But in the last 28 years, most cases that I have encountered were clearly what I would say French version, i.e. being a literal translation of the English trademarks. Now, the rationale here, or the takeaway rather, that you should have here in your mind is it really justified to go about and register the French version of my trademark if I have a registration, or I'm about to have a registration of the English version? So, I mean, in Canada, as you probably know, when you assess likelihood of confusion, you take into consideration the type of consumers that you have. And some consumers in Canada are actually bilingual. So if you have a registration for an English version, in the assessment of confusion, you should take into consideration the French version of your trademark in the assessment of confusion. So registering the French version is something that you need to think about carefully before doing so, because it takes away the triggering of the trademark exception and may force you to use the French version of your trademark in the province of Quebec. All right, so recognized trademark includes both registered trademarks and common law trademarks. Everybody, I believe, understands what's a registered trademark. It's a trademark that's been applied with the federal authority here in Canada, and a certificate of registration has been issued. A common law trademark is a trademark that has been used to a level where it's known in Canada. The level will, I mean, the case law that we've seen over the last years was about cases where the common law marks were quite well known. We don't know what the exact threshold is, but it's probably safe to say that there has to be some knowledge of the common law marks in question by the relevant consumers for it to qualify and trigger the trademark exception in question. Now, what we're going to talk about next is which one of the two makes more sense for businesses to rely upon when entering in Quebec and commercializing their goods and services, in this case, more specifically the goods. So here, as I said earlier, so we got a registered trademark, we got a certificate of registration. If you're the subject of a complaint, you just send a copy of your certificate of registration to the folks at the OQLF, and it puts the matter to rest. If you want to rely instead on your common law trademarks, well, one thing that we've all realized talking to the folks at the OQLF over the last little while is that they're not trademark trained, and they're not equipped, or they've decided over the years that they would not be accepting evidence of acquired distinctiveness or common law rights in front of their organization. Rather, if a business wants to rely on common law rights to trigger the trademark exception when it's the subject of a complaint by the OQLF, it actually has to wait to be sued in court and present its case in front of the court, which obviously is perhaps a riskier proposition than just sending a copy of your certificate of registration to the OQLF. So it's a bit, I would say it's limited, it's burdensome, it's quite risky. And at the end of the day, if a business is not successful in establishing its common law rights, then it could get fined. And as we all know, for those of us who are based here in the province of Quebec, typically being fined is also something that will trigger some media attention that is typically not desirable in the province of Quebec. So pretty bad press if you get down that road and are not successful. So, if you understand what I'm saying correctly, ideally what you will want to do if you want to take a safer course of action is trigger the trademark exception by way of obtaining a registration a lot easier. And the example that we have here is a fake product, thanks to the team at Procter & Gamble for creating this for purposes of our discussions with the OQLF on Bill 96. Assume that the words and the design soapy goddess, divine effervescence are the subject of a registration, then the business that sells this product in the province of Quebec would not have to translate any of those English words. So that's the advantage of the trademark exception. And perhaps that's one of the reasons why Bill 96 has kind of tightened a bit the rules as far as the trademark exception is concerned, and that's what we're going to be talking about next. So Bill 96 has modified the trademark exception as far as product markings are concerned by limiting it or restricting it solely to registered trademarks. And so for product markings, the common law trademark exception will no longer apply. Although the amendments don't really talk about accompanying documentation and those type of publication that Melissa described earlier, I think that all of us practitioners typically recommend to our clients to assume that the restriction of the trademark exception to only those marks that are registered in Canada will likely apply across the board wherever the trademark exception applied before, whether you're talking about product markings, accompanying documentation, online stuff, or advertisement in regular medium or boards and so on and so forth. So it's going to apply most likely at large. So it's kind of a cramp down of the exception. Now, the other aspect of 51.1 that is completely novel and that has generated a lot of ink is the following. So if your registration for a non-French word or words contains generic terms or descriptive language, then the generic term or descriptive language has to also appear on the product or a medium permanently affixed to it in French. Now, and we're going to talk a bit more about that, but that means essentially you have a registration, you may have had a registration for 20 years, 50 years, 100 years, and it contains terms that could be considered generic or descriptive. You're going to have to change your packaging and your labeling, whether or not you've been doing that for way before we were there. And that's the impact of Section 51.1 that will come into force in just under 2 years from now. Now, so as I said, it's going to be restricted to registered trademarks. The French equivalent of those generic terms will have to appear on the product. So as I said, it will likely apply to commercial publications as well. And then we'll try to explain on the next slide what are the questions that this generated. I think that it's safe to assume that generic means the actual name of the products. So if the product is a soap, I think it's safe to say that if soap is part of the registered trademark, you're gonna have to put the French equivalent somewhere on your packaging. Now, Melissa talked to you earlier about Section 51 that says that you can have both French and another language on your product or the accompanying documentation, but the French has to be at least equivalent to the other language. 51.1 is right under 51, so we assume that the French version of the generic or descriptive term is going to probably have to be of equal prominence to the generic or descriptive term, unless we see some regulation that says otherwise. That is kind of the interpretation that we're making of this. Now, and again, the way 51 is drafted talks about on a product. So when the trademark appears on a product, but you have to remember that the folks at the OQLF are not trademark people. So for them, a product is whatever a consumer goes to buy in the store. Now, if it's something inside of a container or a box or whatever, the product is what you buy. And so if it's a box, then it's actually the container or potentially the packaging that bears the trademark that contains the generic or descriptive language that will likely have to be translated into French and to appear on the surface or something permanently affixed to it in a size or prominence that's going to be equivalent to that of the generic or descriptive term on the product, but product being interpreted in a generous fashion here, most likely. Now, again, we're talking about all this and those questions. We don't really have much guidance from the OQLF at this point because they promised regulation actually in November of last year, but the regulation was more likely to target the signage. We've spoken to them a number of times since then, and hopefully they've understood that the regulation and the guidance would have to also apply to the product markings. Why? Well, because we have so many questions. So I said earlier that, yeah, generic may be, I would say, generally well understood, but descriptive. What does descriptive mean? What does it mean? I mean, we're trademark practitioners and we argue amongst ourselves about what is descriptive or not. Imagine how non-trademark trained people are going to determine what is descriptive or not. Is it going to be the case law in front of our federal court or our trademarks office that's going to be the guidance? Or is it going to be something more restrictive, in line with what the Minister of the French language at the time was suggesting, giving examples that were, very restrictive in terms of interpretation of what descriptive means? For example, saying that a product is vanilla scented, for example, would fall into what the minister in his comments at the time was referring to as descriptive language. And if those descriptive terms were covered by the registration, then those terms would have to be translated in French and put on the product so that consumers that are not English speaking faced with the product would be in as good a position to understand what they're buying as somebody who speaks English. So that was the rationale behind this. So, but we don't know yet how the office is going to actually interpret the meaning of descriptive. Now, we've got also other questions. Anywhere on the product, its packaging or container. Well, is the more favorable term that Melissa described going to apply to that as well? In all likelihood, yes. Now, oftentimes those descriptive terms already appear on the product because of it's the name of the product itself, and by federal legislation, it has to appear on the product, but it's probably not big enough. So businesses are going to have to take that term that already appears on their packaging and oversize it to actually match the size of the term in question that is part of the registered trademark. Something else that we've questioned the OQLF about, what does it mean a medium permanently attached to the product? You're buying a pair of shoes and you're going to carry something that flaps on the side of it forever? How does it work? And so, does it have to be permanently attached up to the point that you purchase the product so that you're informed of what you're buying at that time? Or does it have to stay with the product all the time? This is one of the very few questions we've asked the OQLF, and we actually got an answer. They said it has to be permanently attached to the product for its entire lifetime. So that's one of the very few questions for which we actually have an answer. The size of the translation we've already addressed, so it's likely to be as prominent as the non-French version. Now, again, we went in front of the OQLF with those. It's a sampling of the examples just to show how difficult it is to determine what falls into descriptive or not. Here in all those examples, I think it's safe to say that hand soap is generic. And so that's why in these examples, it's already translated into French. So I think it's safe to say that this is a good interpretation. However, Aphrodite, I think we all agree that's not an English word, it's a name of a goddess, but zesty lemon scent. Now, is that descriptive or is it suggestive? Perhaps some people will say that lemon in and of itself is descriptive, but not necessarily zesty. Or lemon scent, the lemon scent part perhaps is descriptive. You look at the other one and it says goat milk, and you have a little image of a goat. What about universal language? You have a goat, an image of a goat. So clearly the Quebec consumer understands that there's something coming from a goat in there. Otherwise it's misleading. Do we have to translate goat milk because the soap contains goat milk? Perhaps yes. Tropicality. What is that? Is that a term that describes a characteristic or whatever of the product so that it needs to be translated? Or is it more like really suggestive, something that, would not need to be translated under 51.1? Same thing with professional, and even more with feels good. I mean, I guess that describes the state you feel in after you wash your hands with that soap. So we've asked those questions, we've received essentially no answers. So this is now the time for me to turn it back over to you, Melissa.
Thanks, Christian. So circling back to signage, similar to product packaging and labeling, currently recognized trademarks are exempt from French translation on signage, provided, of course, that no French version of the mark has been registered. However, come June 1, 2025, again, that exception is going to get restricted to registered trademarks only, such that common law trademarks will have to be translated to French if they're not formally registered by June 1, 2025. Both the current rules as well as the forthcoming rules for outdoor signage differ, however. So what is the current state of the law as it pertains to outdoor signage? You may recall that back in 2016, the charter was amended to introduce a requirement for the sufficient presence of French to be ensured when displaying a non-French trademark in outdoor signage. And that sufficient presence of French could take the form of, French generic copy, terms, words, or a French slogan. And the French copy needs to only be permanently visible, legible within the same visual field, and there are rules to ensure legibility within the same visual field, and those rules vary depending on whether the trademark is visible from the sidewalk or from a rooftop, and the French copy needs to be illuminated if the trademark is lit. So here are examples that were provided by the regulator back in 2016, and you can see here that Cool Kids is an English trademark, presumably, and you can either add generic words such as vêtements, which is the French word for clothing, so presumably this is a clothing retailer. You can add a slogan, additional descriptive copy, etc., to comply with that sufficient presence of French requirement. So those are the requirements that were introduced back in November 2016. You'll notice that they did not really speak to, or they didn't at all speak to, the prominence of the sufficient presence of French. As of June 1, 2025, the sufficient presence of French threshold will be amended to include a new prominence requirement, and specifically that the French copy accompanying a non-French trademark on outdoor signage be markedly predominant. And I think we can actually skip ahead to slide 27, please. And so again, what does markedly predominant mean? Again, we have an existing regulation that defines this term. However, the government has indicated that the requirements will be further defined in the regulations. But if we base ourselves on the current definition, this would mean that the French copy would have to be in font size twice that of the English trademark. And so if we go to the next slide, this is what that would presumably look like. If we use the example that was provided by the regulator back in 2016 and do a bit of copy pasting editing, the word vêtement would have to be in font size twice as large as Cool Kids. And as you can imagine, companies will not only have to allocate considerable funds to once again update their outdoor signage, not 6 years later, but they'll also have to contend with municipal signage laws, which often have very strict rules regarding signage sizing, which means that it may not be sufficient or compliant to just increase the font size of that French copy that would have been added back in 2016 to your outdoor signage, but rather potentially reducing the font size of the trademark that's currently displayed and increasing the font size of the French copy. So switching gears now from trademarks and signage to contracts. Earlier this month, the new French first rule came into force. And so previously, contracts of adhesion could be drafted in English at the express wish of the parties, if that is what the parties intended or wish to do. And by contracts of adhesion, we typically mean contracts that are predetermined by one party, kind of take it or leave it agreements. So that was the rule under the previous section 55. The new rule is quite a bit more onerous and will require the adoption of a two-step process. And the reason we kind of informally refer to it as the French first rule is because step one requires that a completed French version of the agreement be remitted to the consumer or the adhering party. And only once you've remitted that French contract can the parties explicitly express their willingness to proceed and transact in English. Luckily, there are some exceptions to this rule, such as for loan agreements and contracts used in relations with persons outside Quebec. However, that exception is rather broadly worded, and it's our hope that the regulations, or at least additional guidance from the OQLF, will enlighten us as to what type of contracts are considered to be, quote unquote, used in relations with persons outside Quebec. The French first rule also applies to certain consumer agreements and has made its way into the Quebec Consumer Protection Act as well. So for instance, Itinerant merchant contracts, so door-to-door direct seller agreements, contracts with cell phone and internet providers, as well as consumer credit agreements will also need to follow the new two-step process. And I will now hand it over to Karina, who will speak to us about the French language obligations in the labor and employment sector.
Thank you, Melissa. So one of the fundamental language rights that's enshrined in the Charter of the French language is the right of Quebec employees to carry out their activities in French. And there's two sets of rules that are included in the Charter that apply to employers and are meant to ensure that employers respect their employees' right to work in French. There's a first set of rules that applies to any employer that has employees in Quebec, regardless of how many employees it has. And there's a second set of rules that applies only to larger employers. Currently, those are employers which have in their service 50 persons or more in Quebec over a period of 6 months or more. These businesses have to comply with additional obligations that are known as francisation obligations. These obligations existed already in the Charter of the French language prior to Bill 96, but the major modification brought in by Bill 96 in this respect is that the threshold as of which francisation obligations are going to apply is 25 employees of a company in Quebec. There's a transitional period for this change. So companies that currently have between 25 and 49 employees in the province of Quebec have until June 1st, 2025 to start the francisation process with the office, about which I'm going to talk shortly. So as far as the rules that are applicable to every employer in Quebec are concerned, the main obligation is for employers to respect their employees' right to carry on their activities in French. This general, broadly worded obligation is also supported by specific requirements that Quebec employers have to comply with. And these requirements touch many of the documents and many of the aspects of a workplace. So for example, for offers of employment, transfer, or promotion, there's a requirement for these offers to be drafted in French. They can be published in French and in English, but there's a requirement for the publication of the two versions to be done in English and in French simultaneously and through the same means of transmission, reaching a target audience of comparable size. So that simply means that if the French version that if the English version is published online, then the French version should also be published online on websites with similar reach, not having one online and the other one in a regional newspaper. In addition, with respect to the content of such offers, if the employer is going to require that a candidate have knowledge of English, then that requirement has to be identified in the offer. And the rationale for why the requirement was imposed also needs to be identified in the offer. There are specific rules that apply to individual employment contracts, which generally mirror the French first rule that Melissa has just described, where contracts of adhesion are concerned. Now, determining whether or not a particular contract actually qualifies as a contract of adhesion or a negotiated contract requires a case-by-case analysis. But I do want to mention that the Office of the French language generally considers that individual employment contracts are going to constitute adhesion contracts. So it's prudent to assume that these rules are going to apply to the vast majority of your employment contracts in Quebec, with the possible exception of contracts for very senior or C-suite executive employees. There's a requirement for employers to communicate in writing with their employees. Sorry, could we go back to the previous slide? Thank you. There's a requirement for employers to communicate in writing with their employees in French, whether the communication is going to one employee in particular or to a larger group of them. And although an employee can request that the employer communicate exclusively with them in English. Finally, documents such as employment application forms, documents relating to conditions of employment, which can include handbooks or employment policies, and training documents produced for staff, and such as standard operating procedures or instructions for how to procure certain types of tools required for performing one's job, have to be provided to employees in French. If the document is bilingual or there's two versions that are provided, then the French version has to be available on terms that are at least as favorable as the English version. So I mentioned earlier that if an employer is going to require a candidate to have knowledge of English for purposes of getting a job or a promotion or retaining a job, that rationale has to be mentioned in the offer. The charter actually prohibits employers from requiring such knowledge of English unless the nature of the duties associated with the position requires the knowledge. And employers must take all reasonable means to avoid imposing a requirement to have knowledge of English or a specific level of knowledge of English. And to do that, employers have to first assess what are the actual language needs associated with the position. Second, make sure that the language knowledge that's already required and provided by other staff members is not sufficient to carry out those duties. And finally, the employer has to restrict as much as possible the number of positions whose performance requires knowledge or specific knowledge of English. If an employer does not meet these three conditions and doesn't take the three steps that I have just mentioned, then they're going to be deemed not to have taken reasonable means to avoid imposing the requirement. I do want to mention that the charter does specify that the requirement and the rules surrounding when knowledge of English can be required from employees must not be interpreted in a way that imposes on an employer an unreasonable reorganization of the employer's enterprise. So prior to Bill 96 coming into force, corporations that were registered on the Quebec Registry of Enterprises had to declare how many employees they had in the province of Quebec. With Bill 96, a new obligation has come into effect, which actually just came into effect as of June 1st, 2023, whereby employers that have between 5 and 49 employees in the province of Quebec have to declare what proportion of those employees is not capable of communicating in French. And this information is provided in the declaration that has to be submitted when the corporation registers on the Corporate Registry of Quebec, if this registration happens for the first time after June 1st, 2023, or in the case of a corporation that's already registered, it's going to have to be provided in the updating declaration that the corporation must submit, either the annual declaration or just a current updating declaration whereby some information gets changed. This information is going to be publicly available. It's going to appear on the Quebec Registry of Enterprises. And in fact, that field is already active and apparent online. And the Office of the French Language, in collaboration with an entity called Francisation Quebec, is intending to use this information to identify on an annual basis what sectors of activity have less prominence of French among the employees that work in those fields. And the office and Francisation Quebec will send companies in these sectors an offer to set up French courses for the workforce. Finally, as I mentioned, there's a specific set of obligations called Francization obligations that apply to larger employers. The purpose of these Francization obligations is to ensure that the use of French is generalized at all levels throughout the business in businesses that reach the required threshold of employees, which, as mentioned, currently is 50, but will be reduced to 25 as of June 1st, 2025. This process starts by employers having to register with the Office of the French Language once they reach the threshold of employees. And after the registration is done, then the Office of the French Language sends businesses a certificate of inscription. As a third step, within 3 months of receiving the certificate of registration, the business has to complete the linguistic analysis and submit that to the OQLF. The linguistic analysis is essentially a canvas of the use of French in pretty much all of the business's operations, whether that's internally in respect of its employees, in the use of technology resources employed internally, in communications with employees, but also with customers, with clients, in packaging, pretty much all of the obligations that the charter creates for businesses operating in Quebec. If a company has 100 employees and more at the time that it goes through this process, it will need to inform something called a francization committee, and it will need to communicate to the Office of the French language at the time it submits the linguistic analysis, the composition of the francization committee. The francization committee has different roles and responsibilities within the business. It's formed of, in the case of a company that has 100 employees or more, of 3 members chosen by employees and 3 members chosen by the company. And it essentially sees to it that the use of the French language remains generalized in the business, or sees to the development and implementation of a francization program if required. As a 4th step, once the Office of the French language receives the linguistic analysis, there's 2 possible outcomes. Either the Office of the French language is going to consider that, based on that analysis, the use of French is generalized within the business at all levels, in which case it's going to issue a francization certificate, or it's going to notify the business that it has to develop and implement a francization program to increase the use of French, to make it so that it becomes generalized at all levels of the business. And with the goal, of course, that once the business has implemented that program, it can eventually receive a francization certificate. And once a business is certified, then reports must be submitted to the office every 3 years on the use of French, because the office wants to ensure that the generalized use of French within the business is maintained in time. I'm going to turn it over to Melissa now to talk about briefly the enforcement process.
Thank you, Karina. So I'm mindful of time. We'll kind of go through this very quickly. In the event of non-compliance, there are, of course, fines, which have been increased and now range from $3,000 to up to $30,000 for a first offense. And those fines are doubled for a second offense and tripled for offenses thereafter. And since each day constitutes an offense and the OQLF can fine you on a per diem basis, companies can rack up rather significant penalties. So imagine being in market with a non-compliant product. We can take the example of the hand soap with goat milk not translated to French. You're in market with that for 30 days at the minimum fine of $3,000 a pop. That amounts to $90,000 in fines for just 1 month of non-compliance. And that presumably is for, a product sold at a single retail location that can obviously multiply based on a number of different locations that you sell through or in Quebec. So the charter certainly has sharper teeth to it now. In the case of a contract of adhesion that does not comply with the new French first rule, the provisions of the contract that cause injury to a party may be declared null and void. In certain cases, the contract may be declared void ab initio, and ultimately contracts in violation of that rule are unlikely to be binding.
I'll close out the topic of enforcement by speaking briefly about employee-specific remedies. So employees have a right to a work environment that's free from harassment or discrimination because the employee has little or no command of a language other than French, because the employee claims the possibility to express themselves in French, or because the employee has demanded that a right arising from the charter be respected by the employer. Employers have a positive obligation to take reasonable means to prevent such discrimination or harassment from occurring, or to make the behavior cease if something is brought to their attention. Similarly, employers cannot impose sanctions such as layoff or dismissal on employees because of a number of prohibited practices identified in the charter, but essentially because, again, the employees would request a right provided for under the charter to be enforced, or because the employee does not have knowledge of a language other than French, where the performance of the duties does not require such knowledge. If an employee believes that they've been either discriminated against or harassed or the object of a prohibited practice, they can make a complaint to the Quebec Employment Standards Regulator. And if the complaint does not otherwise settle through a mediation process, then the matter is referred to the Administrative Labor Tribunal, which can order various remedies at the outcome of a trial, including cancellation of the sanction in order to cease practicing discrimination, or even reintegration of the employee if a dismissal occurred in the case. So I'm going to turn it over to Susie now.
Okay, thanks. Okay, so this is definitely going to be potentially very onerous for US brands that are active in Canada, but hopefully I have some good news regarding US trademark rights and how they'll be affected under Bill 96. So decisions of foreign courts are generally not relevant to trademark rights in the United States. Both the US courts and the Trademark Board have held that decisions of courts or trademark registration offices outside the US are not relevant to ownership and enforcement of trademark rights within the US. The case here is Fuji Photo Film, where the court is saying it is equally well settled that when trademark rights in the United States are being litigated by an American court, the decisions of foreign courts concerning the respective trademark rights of the parties are not relevant and inadmissible. So generally not relevant. Next slide. However, decisions of foreign courts can sometimes be relevant to trademark rights in the United States. This is, this is not new. The decision of foreign trademark registrations office can be relevant to the generic status of a non-English word claimed to be valid trademark in the United States. So if you have a trademark in Canada in French, and you're trying to register that mark in the United States, the fact that you've conceded that it is generic or completely descriptive in Canada in that situation, that could affect your trademark rights and your registrability in the United States. So that's the issue here.
Okay, thank you so much, Susie, for providing a little bit of US color to what is, I think, uniquely a Canadian and Quebecois issue. We're going to have a little bit of a back and forth discussion, and I'd like to invite all of our participants and everybody who's watching today, if you have questions, please go ahead and drop them into the Q&A. And I will take a look at that, and I will throw those questions over to the right person. But let me kick off with a question about the private right of action. Christian, you mentioned earlier on that there is also now a private right of action that is coming up under Bill 96 that did not previously exist. And Karina mentioned the private right of action for employees. And I'm wondering if you could provide a little bit more detail, if we know, of what that private right of action might look like in the trademark and signage context, specifically when something is not sufficiently presented in French, or where the French is not presented in a manner that is consistent with the Charter's requirements.
Well, thank you, Kimberly, for that question. And of course, I invite others who presented today to throw in whatever comments they feel might be a good addition. So essentially, the fear here is that not only can businesses be sued by individual who, instead of filing a complaint with the UKLF, decide to take matters to court on their own. This could be a pretty onerous process, very expensive for individual, but not necessarily so much if they decide to group together and launch a class action against a specific targeted business. And that obviously is a fear that has a lot of, I would say, convincing power, and is something that cannot be neglected by businesses doing business here in the province of Quebec. So it's this fear of a class action by a bunch of individuals that could feel that their rights to be serviced in French is not respected.
Do we have any read yet on what those damages or the remedy might look like?
I'm not aware of any actual case law. This is already, I believe, in force. I am not aware of how far this could go in terms of consequences.
Gotcha. Thank you so much. I have a question for Melissa. And thinking about the French first rule for contracts of adhesion, would you say that a website's terms of service and privacy policy would fall within the scope of the French first rules requirements, and specifically that two-step process for gaining acquiescence to the English language being controlled? Or do you think that terms of service or terms and conditions of a website and privacy policies that dictate use of information on that website are part of the exemption?
That's a great question. I think terms of sale and terms and conditions of a website likely would fall within the scope of a contract of adhesion. I think a privacy notice, it's not entirely clear quite yet. And I think that's where we're kind of hoping that we'll get more guidance from the regulator on, well, what do you consider to fall within the scope of the French first rule? The issue that I have in the comments that I've submitted to the regulator on this are with respect to transacting on the English version of an otherwise compliant and fully translated to French e-commerce site, right? And so if I, as a consumer, have elected to transact on the English version of a website that is otherwise available in French, there should be some exemption in the forthcoming regulations that recognize that if I've made that choice, then that French first rule should not apply. Because if not, the effect that would have is effectively you would require, on the English version of a site that is not only targeted to Quebec, but generally to, consumers across the globe, there would have to be some form of pop-up to say, here's a French version of our terms of sale and terms and conditions. Please click here to confirm that you've received them, following which you can, agree to be bound by the English version. I think intuitively, if you're transacting on the English version of a bilingual website, that there should be a presumption that that requirement should not apply. But we'll have to wait and see.
Thank you. I feel as though the answer to a lot of these questions may be we will have to wait and see, as a lot of this is still being shaken out in that in some respects, the OQLF is still developing guidance and regulation on pieces that are coming into effect now or will shortly come into effect. Speaking of, Corina, I'm curious, how are employers supposed to measure or assess French language capabilities? The corporate registry requirement that kicked in June of this year requires a company to say, really what are the French language proficiencies of their employees who are sitting within the province? How is that supposed to be assessed if it's not already evident to the employer?
That's also a great question. Thank you. There's not a lot of guidance that has been released on this yet, but from what's been published by the Quebec Enterprise Registrar and the Office of the French Language, this assessment is supposed to take into consideration the nature of the tasks that an employee has to do and their ability to perform those tasks in French. So for example, if the employee is in a sales position, are they able to communicate with their clients in French? Are they able to read French materials and communicate with their colleagues in French or with their possibly with suppliers? It's really looking at the universe of tasks associated with a position and saying, can this employee carry them out in French?
Thank you. I appreciate that. Susie, I'm curious, thinking in light of the last case that you put up, which was with respect to a term that was viewed as generic or descriptive in a foreign language that was then being used in a US mark. Do you believe that the strategy of avoiding a direct translation into French for an otherwise descriptive or generic term would help a US marks holder under that case law? So if you take, for example, a product that is, let's go back to our soap example, and instead of it being soapy goddess, it is soap goddess. And the word soap then is generic and is presented in French as savon. Then what, if anything, does that do with respect to the US mark holder and their ability to protect that aspect of their mark? Does it weaken their rights under that case? Do you think that there are ways to avoid that, such as finding a transcreative phrase instead of a direct translation?
I think potentially it could, and I kind of thought of a lot of different like random situations about how it could get you into trouble in the US. Any determination of genericness in any other office, if you are using that language, is going to be a problem in the US 100%. And that's been true before the bill, and that'll continue to be true. So resisting the determination, if you're going to take that back to the US, is a good idea for sure.
Thank you. I appreciate that. That actually gives rise to a question that I know I've been carrying in my mind, but it also happened to conveniently come through on the Q&A, not once, but twice, which is, and I'll throw this over to Christian and Susie, if you have any thoughts, or Melissa, of course, I welcome your thoughts. Given the restriction of protections to only registered trademarks and eliminating common law trademarks from this exception, which previously had already existed for them, and taking into account that even a registered mark may require some seeding of descriptiveness or genericness of portions of a mark, do you see there being any potential issues under CUSMA if you are in Canada, or USMCA if you're sitting in the United States, specifically under the trademark protections within that treaty between Canada and the United States?
You want to take it, Susie, or do you want me to start?
I think that's you.
So, you know, from the one hand, you can take the position that nobody's forcing you to translate your trademark, or well, yes, you have to translate parts of your trademark, but the trademark itself can, I would say, keep its integrity. All that they're asking you to do is take a word or words within the registered trademark and translate them into French and put them somewhere else without necessarily altering the brand itself. Now, is that an undue burden that is added on the shoulders of brand owners that come and sell their products into Canada? That's an argument that, in my mind, has definitely some traction. It's been tried in the past, hasn't been very successful, at least in the context of plain packaging and so on and so forth. But I think that it's something that is a good argument. I would be very interested to see how it will do in court. I think it makes sense, especially in view of the language of our Trademarks Act that gives you technically the right to use your trademark. And then you come into the province of Quebec and you have to actually translate portion of your trademarks to comply with provincial legislation. Is there a conflict there? Not necessarily with CUSMA from a Canadian perspective, but also from a provincial versus federal statute perspective. Is that something that will give rise to some constitutional challenges? It remains to be seen, but I'm sure that there will be circumstances where it will be close to something that is potentially problematic. But to this point, we haven't heard anything from the federal government on this. We've tried to hear what they have to say about that, but they remain silent until now.
Melissa or Susie, anything to add? It's okay if the answer is no. There's also another really good question in the chat that I want to highlight that really looks at again, common law or even pending applications, marks that have pending applications, but they are in use and have some level of acquired distinctiveness. Do we have any thoughts or understanding yet on the relevance of court decisions that acknowledge and confirm common law status or acquired distinctiveness, how that will bear on OQLF's determination, or is it even relevant if it's just not registered, it's not registered, and that's the end of the analysis?
So should I take this on, or someone else wants to take this on?
Sure.
I can. So, I mean, there's a multiplicity of questions in there. So one of the questions I hear is, if you have a pending trademark application, does it qualify as a recognized trademark, at least until the new criteria kicks in on June 1st, 2025? The official position of the OQLF, to my knowledge, has always been that a pending application does not trigger the trademark exception, although I know that some inspectors at the OQLF have accepted a copy of a pending application as proof that the trademark was recognized, as required under the Charter of the French language. But I've asked the questions, and the answer I've received is that that has never been part of the trademark exception. But as I said, I know for a fact that they've accepted pending applications as proof of recognized trademark in the past. So that's one piece. Now, do we have case law to, sorry, Melissa, just a little bit more, and then I'll turn it to you. There is case law in Quebec on what is a recognized trademark. The latest decision I remember is a trucking company that has been operating for a long period of time. Perhaps what we can do is send to the attendees the couple of cases, at least that I know about, and maybe others know about cases as well. But the one that pops to my mind is the trucking company from a few years ago. I'm turning it back to you, Melissa.
Thanks, Christian. I just wanted to offer some comfort there, because in our discussions with the regulator, what they've indicated to us was, we're going to, we've always taken a flexible approach to enforcement, and we're going to continue to take a flexible approach to enforcement. And so what I've heard is, as long as you've registered or filed your trademark registration as soon as reasonably possible, they're unlikely to pursue or take action, right? And their intent does not come June 2nd, 2025 to start finding companies that are using unregistered trademarks and not translating them to French. They do want to work with companies to ensure compliance. But then that also begs the question, well, okay, so we have, a little bit less than 2 years now. We know that these, this rule is coming into force on June 1, 2025. And so we can do the audit of our marks and ensure that we file prior to that date, right? But what about new brands or new product lines or new marks that we want to roll out post June 1, 2025? Companies are not going to wait 3+ years to get a trademark registration before launching new products. And so I think there again, our hope is that either the guidance documents or the forthcoming regulations will address those situations, because I think that is one that is going to be the most crucial or critical after June 1, 2025. Like, what do we do for new brands and new products?
And Melissa, just to pick up and play the role of a panelist for a moment, one of the reasons why I think that is particularly important that the OQLF come out with either regulation or guidance, or quite frankly, both, is that then becomes a tool that can be used in court in those private right of action cases. Because while the OQLF may very well stand down from enforcement June of 2025, if a mark is not yet registered but is pending, that does not stop a consumer from filing a private right of action as either an individual or as a class. And so if there is not something written that gives mark holders or prospective mark holders a solid defense in court, they still carry some risk with them. In conversations that we have had, I have heard statements to the effect of, well, if it's pending, you're going to still have to present it in French starting in June of 2025, not because we expect OQLF will take action, but because there is a risk with respect to the consumer private right of action. And the follow-on statement to that I have heard is, and once you go to French, you can't go back. So it's really a bit of a catch-22. And so it would be very helpful if we could get regulation and guidance that gives us a legal foundation in court. Let's pivot back over to Karina for a moment, because I feel like we could definitely talk trademarks for hours and hours and hours and hours, having done it before. Are there any actions, Karina, that employers could take to have their Quebec-based employees waive a right to sue under the bill as a condition of employment, such as signing a waiver, and then I will follow on to that. I'm going to tack on an additional piece. What do you do about existing employees for whom you do not have an offer of employment? They have already been working for your company. What, if anything, can you do to kind of retroactively pull another language other than French in as that of the business?
Thank you for that question. So with respect to the first part of the question, I don't think that it's possible to have employees sign a waiver by which they would, for example, renounce the remedies and the protections that they have under the charter. I think even if they were to sign something like that, it would likely be unenforceable against them, because the charter and the protections it creates would be viewed as being of public order, meaning that you can contract out of something like that, unless the charter specifically says, like it says, for example, for the rule on communicating and writing with employees in French, the employee can request that the employer communicate with them exclusively in English. So that's one where the charter says there's a carve out there. With respect to the second portion of your question, I think it depends on when that contract was signed. So the rules of that we've discussed about individual employment contracts came into effect on June 1st, 2022. And there was a transitional period whereby employees that had signed an employment agreement prior to that date had a year up until June 1st, 2023 to ask their employer for a translation of the contract in French. So I would say that for anything that was signed prior to June 1st, 2022, it's either that employee has already asked for a translation to be provided, or they haven't, and then any questions around the validity of that contract are going to be governed by the rules that were applicable prior to June 1st, 2022. If the contract is signed after June 1st, 2022, and the French first rule is not followed, then I think that there's the potential for enforceability issues with that contract. And that, of course, and it can be a significant problem depending on what protections the employer had in that contract that they might not be able to rely on.
Thank you. That's very, very helpful. Appreciate it, Karina. Back over to, I think this is a Melissa question. Do you think that the French first language requirements will apply to highly sophisticated B2B products, such as scientific products sold to businesses, pharmaceutical manufacturing, biopharma, life sciences? You could probably scale that out even to machinery for manufacturing. And I think that the question really applies not only to the contracts, but also to any packaging and associated items that come along with those high-tech products.
So I think there's probably a number of questions embedded in that one question. If we're talking about inscriptions on packaging, so product packaging and labeling, there is currently an exemption for products that are medical in nature, or that are for scientific purposes provided, and there are a number of conditions, but one of them is provided it's not intended for retail sale, it's going to be used for medical or scientific purposes, and it meets certain weight or sizing requirements. So that's in the regulations. There's currently exemption for that. With respect to the French first rule, I think we kind of have to go back to kind of the primary principles and assess whether or not, firstly, that is a contract of adhesion. So if we're talking about two sophisticated businesses and this is a heavily negotiated agreement, well, that's not going to be a contract of adhesion, and the parties can then elect to transact in whatever language they would like. And so what we would recommend in that case is the inclusion of kind of that famous language selection clause, which is presented in both English and in French, typically before the signature line, that says the parties hereto have requested that this agreement and all related documents be drafted in the English language.
Thank you.
Can I add a couple of comments, Kimberly, if you allow me?
Absolutely.
So trying to be practical from my perspective, the risk for a business that is in the B2B space, when it comes time to actually sell its products or offer its services to another business, the risk of being the subject to a complaint is probably very low, because the complaint process typically is triggered by consumers in Quebec that are faced with a product or a service in their daily lives while shopping around or walking around the city or whatever. And then they feel that their rights are not being respected, they file a complaint with the OQLF, and the whole process is initiated. The risk of a person like that seeing, for example, a product that is highly sophisticated, like you've just described, being sold from one business to another business, very, very few people see it in practice. The risk that there will be a complaint triggered is probably extremely low. In fact, I know of businesses that have been selling their goods and services here in Quebec for decades, and they've never received a complaint and don't necessarily comply 100%. At the end of the day, I would say most of us never actually see their products or services. So this has to be taken into consideration when assessing the realistic risk of the coming into force of these dispositions in a little bit under 2 years from now.
I think that's right, and that's a very fair point. I think we have to understand that enforcement is largely complaints driven. I think based on the OQLF's latest statistics, 98% of complaints are amicably resolved and don't make their way through the courts, and companies are not ultimately fined, or only 2% of them are ultimately fined. So I think taking that into consideration, and the fact that, again, if it is in the B2B space and the products or services in issue are only going to be used or seen by a very limited number of employees within those organizations, I think the risks are generally speaking relatively low.
I will throw this next question out to all three of the Canadian lawyers on the panel. Are you hearing anything from your contacts at OQLF regarding the status of regulation or guidance in your respective areas of expertise? And if there is no regulation or guidance forthcoming in the next, let's call it year, is there any indication that the implementation of the June of 25 provisions will be delayed or deferred?
Should I start?
Go ahead.
So we've been in touch with them up until very recently. We have no idea when the regulation is going to come out, as far as at least the trademark exception is concerned, 51.1, 58.1. In fact, as I mentioned earlier, first time we spoke to them about 51.1, the comment we receive is, why should we provide further guidance on a section that is crystal clear? So, and then we asked a few questions which remained unanswered, and then hopefully made the folks at the OQLF and at the Quebec government realize that what they thought was crystal clear is not. And so we hope there will be regulations, but we just don't know, and we don't know when, unfortunately. And I do not expect that the coming into force will be delayed a single minute. At least that I am pretty certain of to this day.
I echo Christian's comments there. When we asked as recently as a few weeks ago, the response was, we don't know, right? We don't know when the draft regulations will be published. In terms of the guidance documents, we've been told those are underway. They're working really diligently on them. However, I suspect those are guidance documents pertaining to the provisions of Bill 96 that are already in force. Because the ones that are coming into effect on June 1, 2025, to Christian's point, there's a lot of, there's a lack of clarity with respect to many provisions, right? And how that's going to play out in 2 years from now. And so I think we need to we can't put the carriage before the horse. I think we need to wait for the, final version of the regulations, not just draft, but a final version before guidance on the interpretation application of those provisions can possibly be published.
And I can confirm that we've received the answer to that question from the Director of Legal Services at the OQLF, that the guidance will not come before the regulation is out, for the exact reason that you've mentioned, Melissa.
Karina, how about in the employment sphere? Is there any reason to believe that there's further regulation or guidance that's forthcoming? And if not, any word that they would delay implementation of the reduction of the threshold from 50 to 25? Do they have the resources to deal with the increase in franchisation reporting?
I echo Christian's comments that there's not going to be any extension of the coming into force of that reduction in threshold. I don't know that there's going to be additional regulations in the employment space, but the office is quite active in terms of publishing guidance for businesses in terms of how to comply, for example, with the new requirement to not demand knowledge of a language other than French from an employee, except where the duties require it. So they've published guidance on that. They've also been publishing extensively on how to comply with the Francization obligations and what the process is, how and what the different steps are, what's required at each step. So I think that there is an effort to educate and to publicize what those requirements are and to assist businesses that are in the threshold of 25 to 49 or nearing that threshold to get ready to comply.
Thank you. Susie, I'm just curious, having spoken with us over the last few weeks as we prepared for this panel and hearing everything that's going on today, do you have a sense that your US-based clients who do business in Canada are sufficiently aware of these provisions? And if not, do you have any thoughts for how we within the legal community, other than webinars such as this, can get the word out as to the scope of this kind of beast, not in a bad way, but it is a massive piece of legislation. Any thoughts on that for those of us who deal with US-based entities?
I mean, tell your friends. Post on LinkedIn. I think it's a little bit unbelievable that's going to be a process. Like I would tell my clients, I've started telling my clients now, because I think there's really going to be stages, similar to with grief, how it's denial before you do get to acceptance. And plus there's just a lot of unknowns here. So, as attorneys, we don't love that unpredictability of this, but I think that's another thing that you're going to have to get your clients to, have be comfortable with.
Thank you. And one last question, and I'm actually going to ask Melissa this because I believe that you periodically play in the litigation sphere. And it's a good question, I think, particularly for US lawyers who hear the phrase class action and a chill goes down their spine. Are class actions as common in Canada as they are in the US, number one? And number two, are class actions common in the province of Quebec?
Yeah, I saw that question come in and I actually wanted to address it before we jumped off. Quebec is certainly known as the class action haven of the country. With that being said, Canada is nowhere near as litigious as the US is. And so is the class action risk higher in Quebec relative to other provinces? Most likely. And I think for a number of reasons, and probably because one of those reasons is likely because Quebec has kind of quirky rules when it comes to consumer protection and French language laws, and kind of like the California of Canada, if you're going to find some odd rules or requirements, it's likely going to be in the province of Quebec. But that being said, I mean, we see a lot of copycat class actions that come in from the US. French language class actions would be something that would be certainly novel and not copycat in nature, but there certainly is a risk of class action litigation.
Thank you so much. All right, we are right at time. And so with that, I'd like to thank everybody for the amazing presentations. This is, as I said, a large piece of legislation. There are a lot of moving pieces, and in many respects, the regulation, which is still under development, and the guidance will continue to change the landscape as we go on. I believe that Stephen is going to close us out, and we will have the CLE number. Thank you to the panelists. And with that, I hand it over to Stephen Petras.
Great. Yeah, thank you. Thank you very much. Hold on, everyone. There is a CLE number that Eric is going to provide. But first, let's thank greatly Kimberly Eberwein, General Counsel of Canada, Procter & Gamble, for moderating this panel. Melissa Terrani at Gowlings for participating. Christian Bolduc at Smart and Bigger. Karina Manot from Torrey's Law Firm, and Susie Ruiz-Lichter from Squires Patton Bogg. Thank you very much. Outstanding panel. I just want to remind everyone, keep your eye out for a November experts meeting in Washington, D.C. on trade sanctions, and also the annual conference in April on human rights and supply chains. We appreciate your involvement with the Canada-United States Law Institute. Now,